So today I am announcing my decision to withdraw the notice of intent to seek the death penalty in the case of State versus Michele Anderson. Ms. Anderson is charged with 6 counts of aggravated murder in the first degree for the mass slaying of her family on Christmas Eve 2007. Now, I initially filed the notice to seek the death penalty because the case, in my opinion, met the legal standard. And I thought that the premeditated murder of 6 people, including 2 small children, qualifies as one of the worst crimes we've ever had here in King County. I thought the jury in each of the co-defendants' cases should have the option of the state's ultimate punishment. The jury in the trial of Michele Anderson's accomplice, Joseph McEnroe, heard all of the evidence in that case, and they found him guilty. The evidence in that case revealed that McEnroe fired the fatal shot in 5 of the 6 murders. McEnroe fatally shot Wayne Anderson and Judy Anderson in their home as they prepared for the holiday. He then took the lead in hiding their bodies, and he set the trap for the next victims. When Scott and Erica Anderson arrived to celebrate Christmas Eve about an hour later, McEnroe was the one who killed Erica Anderson with multiple gunshots. And it was McEnroe who attempted to also shoot Scott, who had been previously shot by Michele. And it was McEnroe who made the decision to kill the children, Olivia Anderson, age 5, and Nathan Anderson, age 3. It was McEnroe who turned the gun on the children and killed them at close range. Now, in May, the jury that heard all of this evidence decided what punishment McEnroe should receive for his crimes. And because the jury was unable to unanimously agree that the death penalty was warranted, the result for him is a sentence of life in prison without the possibility of parole, which is the only other sentence under Washington law. Today we're left with a situation where, following a trial by an impartial jury, one of 2 participants in this horrific crime has received a life sentence for his actions. My decision today to withdraw the death penalty notice in Michele Anderson's case will reconcile the potential outcomes for these 2 defendants and remove the death penalty option for the jury in Michele Anderson's trial. To proceed with the death penalty against defendant Anderson, in light of the sentence imposed on defendant McEnroe, would not be in the interest of justice. Although we could still go forward with the death penalty on the table, it is my decision that we should not. Prosecutors have the responsibility of administering the death penalty in a way that is fair. This act is consistent with that duty. We have fought long and hard in court to preserve the option of the death penalty for the McEnroe jury. And I measure our success in the fact that the jury did ultimately have this option, even though they could not unanimously agree. But now, faced with the trial for Ms. Anderson, an accomplice whom we allege is equally culpable for the crimes, we must take the steps to equalize the potential punishment that she faces. This is a unilateral action by my office. It's not dependent upon any agreement or any action by defendant Anderson. We have long said that the death penalty is too powerful a tool to be used as a plea bargaining chip, and our action today demonstrates that principle. So we'll continue to get ready for the trial in defendant Anderson's case, but it will no longer be a capital case. The notice of the withdrawal of the death penalty will be presented in court today at 3 p.m. I'll be happy to take any questions.
Have there been any discussions about possible plea or plea negotiations?
There's no quid pro quo for this action. It is a unilateral action by my office, and so today in court, the court will start to set a schedule for getting us to trial, and I have every reason to believe we will have a trial in this case. It will be a much shorter trial without the death penalty process involved.
Does this expedite anything? Maybe move it up to dinner fall was what we heard potentially.
You know, those are scheduling matters for the court, and so we'll be ready to go whenever the court sets that here.
Was Michele's mental state considered as a mitigating factor for you?
The action today is, I believe, warranted simply to reconcile the potential punishments faced by people who are equally culpable in the crime, and it doesn't have anything to do with mitigation.
Dan, did the decision in the Monfort case have any role in your decision-making here?
The only impact that the Monfort case had on this decision was that I wanted to wait until that jury did their job, and I didn't want to interfere with that process by talking about the death penalty in a different case.
You said earlier this was one of the worst, or maybe the worst crimes ever committed in this jurisdiction. Do you think it's even possible to get the death penalty anymore here?
You know, it's still the law of the state, and prosecutors have a role to follow the law and to administer the law in a fair manner. I don't know how to predict what a given jury will do, and nor will I ever criticize what a given jury does. The juries in the McEnroe and the Monfort case worked exceptionally hard. Their dedication to stay in the course in a very long trial, having to see evidence was something that none of us would ever want to have to see, and making a profound moral decision about whether somebody should get the death penalty or not. That civic duty really is unmatched. There's nothing else that we ask citizens to do that is as difficult as that. So I will never criticize what they did. They worked really hard and they followed the law as far as I'm concerned. So every jury is going to work its will, and I think our job is done when we have presented a full case to the jury, and then we step back and it's no longer our case. Now it's the jury's case acting as the conscience of the community.
So just to follow up, you correctly said it's still the law of the state, but it's sort of only kind of the law of the state because the governor is essentially suspended the administering of it. So do you think that's affecting juries or your ability to actually get capital verdict?
Well, the jurors who are impaneled in these cases all swear that they can uphold that part of the law, and people who have a moral problem with it or say they can't follow that law, they're not invited to sit on the jury. So there is a selection of people who are willing to enforce the law. Whether the governor's actions or other debate nationally has an impact on juries, I don't know. All I can say is that it is still the law of the state. And if people want to debate the law, I think that's important, just like any other criminal justice reform that we're debating in the nation, that the death penalty belongs on that list of things to be debated, and it can be an informed debate, informed by a 34-year history in the state of Washington. So, but today I'm not really focused on the larger issues. Today, our action is really taken to reconcile the potential outcomes in this most horrific case. And frankly, today we're thinking about the families that have been devastated by this trial. And I met this week with Pam and Tony Mantle, representing so many of the victims in this case, and they have been through 7.5 years of an enormous burden on their life, and I think that they would like this case to be resolved as soon as possible so they can get their life back. And so today's action is also in furtherance of that goal.
So are they in support of your decision?
Yes.
And so back to the potential plea deal again, is that still something that you work toward? You've given up on that because it's been too long? We're taking this to trial? I mean, going through all this again over months, like you say, is going to be really hard.
Well, there is no potential plea deal. This is not, like I say, we did not remove the death penalty. It was some sort of agreement that she would plead guilty. She has the right to trial, and we're preparing for trial, and I expect that we'll have that.
So, could you tell me more about the decision to consider the family in your decision to not do that?
Well, the Mantles particularly, but other family members have been full partners in this process, which is now 7.5 years old, and I regret that it has taken that long. We've been to the state Supreme Court a number of times. Much of the battle was to preserve the option of the death penalty for the McEnroe jury to have, and so I consider that a victory because they did have that option, and the Mantles were in agreement with that. But they're exhausted. They've been through an emotional marathon in this case, and I know that they've told me that they want to get their life back, and they're looking forward to the day that they no longer have to wake up and think about this case. They'll always think about their devastating loss, but to think about oh, we have to go to Superior Court again, there's another hearing or there's another appeal. They've been through more than we would ever ask any victim's family to go through.
Dan, given the outcome of these 3 cases, do you foresee a case in the future where you're going to seek the death penalty?
Well, you know, as long as it's the law of the state, I think the prosecutor's job is to enforce the law. And, you know, I would never say never. There have been horrific crimes around the country in recent months that might qualify under Washington law. So as long as it's the law of the state, we'll continue to try to administer it fairly.
But in this case, or these 2 cases, the defense made it clear that they're going to pull out every possible stop. It's cost $10 million, taken nearly 8 years. How much did that actually weigh in the cost of this, and how much time you've had to invest in the decision to pull back the death penalty?
You know, certainly the cost and the delay are things out of the control of the prosecutor. And maybe that's part of an informed public debate going forward. But right now, I think we're focused on this case and this moment. And I'll look forward to a larger debate, and I would participate in a larger debate informed by our 34-year history with the death penalty law here in Washington State. Other states have recently reviewed their law, and it's, I think, every third of a century or so to go back and look at some of these old policies and say, is this still what we want, is an appropriate thing for people to do. But that's not what I'm launching today.
Clearly, they're going to say that, you know, this is a victory for anti-death penalty supporters. Is this a defeat for the death penalty in King County?
I think that this is a victory for justice. To go forward and to try to seek the death penalty on one participant in a horrific crime when we already know what the price to be paid by the other participant is, knowing that McEnroe personally killed 5 of the 6 victims himself. It's hard to say that Anderson's culpability is greater. We think it is equal to. And so we think that the punishment should be equal, and that's why we have taken this step today.
Dan, I know you said it was a unilateral decision in your office. Did your office attempt to reach, Michele Anderson's side to at least try to get a plea deal of some sort of decision, maybe ask for a guilty, plea in exchange for this? Did you guys actually try?
I wouldn't do that. I have met with her attorneys, but I would not use the death penalty as a plea bargaining chip. It's much too powerful of a tool, and that kind of practice can lead to injustice, can lead to people pleading guilty to crimes they didn't really do just so they can avoid that. And there are those tales from around the country where it has been abused in that way, and we're not going to do that here.
Are you frustrated that you went for 2 death penalties?
I'm sorry, to start over again.
Are you frustrated that with Montford and McIntyre that you didn't achieve and get the death penalty?
So it's always been our philosophy that we succeed in the death penalty case when the jury has that option. And the jury will work their will. And when a jury cannot unanimously find the legal standard and for the death penalty and a life sentence is imposed, we don't consider that a loss, because our victory is won the moment that we are able to give it to the jury to consider as an option. So it happened in the last 2 cases, and so I consider that a victory for our legal team. And it's a long, hard-fought victory.
Nearly 7 years has passed since Michele tried to plead guilty. And is it strictly because of what happened in the co-defendant's case that changed your mind? When you look back on that 7 years, has anything really stuck out in your mind?
The only motivation for this action is that McEnroe received a life sentence, and that I now believe that it would be wrong to go forward to seek a death sentence on someone who's equally, but not greater, in culpability.
Dan, would you be willing to tell us at some point, if not today, what you think should be done with the death penalty?
I would look forward to coming back and being part of a greater statewide discussion of this issue, but today isn't that day.
What's the next death penalty case we have in King County?
There are no more death penalty cases in King County. I'm not sure that there are any pending in the state of Washington.
So you talked about cost, so cost again was not in this decision,
The costs are outside of my control. Our costs are fixed, and our attorneys who handle these cases also have many other cases that they're handling, unlike the defense side, which is is funded entirely to do a single case for as long as that case shall live. So the numbers certainly get out of whack, but that's nothing that I have any control over. Okay. Thank you very much.